Welcome back, everyday Americans. You've rejoined the Constitution study. I'm glad you joined me today. As promised, I have Michael Seufer from the Institute for Justice, and we're going to talk about there's actually, you're dealing with a case out of Norfolk, Virginia. But actually, before I do that, why don't you introduce yourself to my audience? Let them know who you are.
Yes, my name is Michael Seufer. I'm an attorney at the Institute for Justice. The Institute for Justice is a nonprofit public interest law firm that litigates cases nationwide to protect individual rights and liberties.
Yeah, and I like going there because I go to their website and I see cases, and this is one of the cases that came to my attention, especially because I wrote an article about a similar case out of Illinois, but you're dealing with a case out of Norfolk, Virginia, involving the use of the constitutionality of automatic license plate readers.
That's right.
So tell us a little bit
So,
about the case.
of course, the city of Norfolk, Virginia, it's, a mid-sized city of about 230,000 people, part of a larger metropolitan area called the Hampton Roads area. In 2023, the city contracted with a private technology company to install a very extensive network of 172 license plate reader cameras throughout the city. And the police chief has said it would be difficult to drive anywhere at any distance without running into a camera somewhere. And because the tech company that they contracted with also has lots of other customers across the country, but kind of more importantly, locally, the police chief had said it creates this curtain of technology that they can use to track people all over the surrounding area. And every time a car passes one of these cameras, it takes down the license plate and it creates what's called a vehicle fingerprint. That includes the make, the model, the license plate, and then other distinctive features of the car. So if it has a roof rack, if it has a bumper sticker, they say they can even pick up things like a damaged rear fender. And that all makes it really easy to track the car from one location to another because it stitches together all of the pictures and captures of people's cars over time. The vendor keeps records for 30 days and then it purges them. So it just has this constant running 30-day record of people's movements where police can kind of go back in time and see, where you were traveling, and figure out all sorts of private details about people's lives. And they do this to everyone who drives through the city of Norfolk. I mean, back in the day, if you wanted to follow someone for 30 days at a time, you'd need a whole team of police to follow them, to keep tabs on them. It's the sort of thing that would have been reserved for like Al Capone, the most notorious criminals and the most notorious crimes. And now Norfolk is just doing that to everyone. Everyone lives under that type of surveillance in the city of Norfolk.
So again, from a constitutional standpoint, I see two things that I focused on. I focused on the same things in my article. First is the question of the expectation of privacy. Right? When you're in public, when you're traveling through the public, you have an expectation, you have no expectation of privacy. So the idea of taking photographs, it's the same justification for your doorbell camera, your dash cam, and even police body cams. So is the issue the taking of the pictures or what's being done with the data?
It's not the taking of individual pictures. So this is one thing we argued successfully in our case, and got the court to deny the motion to dismiss. There's a difference between being photographed by an individual camera and being tracked by a whole system of cameras, right? When we go out into public every day, we see other people. We expect to be seen. Someone can see you at CVS, the grocery store, anywhere else you go, right? Like that isn't weird to us. That's something we just deal with as part of living in a society. The difference is if you kept seeing a person day after day at location after location, it would be creepy, frankly. You would assume that they were stalking you. And that is something as a society we expect people not to do. We have a reasonable expectation in our long-term movements. So even though these isolated movements in public aren't protected by the Fourth Amendment, what the Supreme Court has said is the whole of your movement is protected. And kind of, going back to my analogy, the way courts think of this sometimes is in terms of founding era analogies. Um, whether this new technology is really just accomplishing something that the police have just always been able to do without technology, or if it's adding to something, it's adding some new capability that the police just couldn't have accomplished before. And when we go back to the founding, I mean, there weren't many police officers then. Most of them actually worked part-time. A lot of criminal investigation was done by private parties, and police officers couldn't do much of anything without the supervision of a judicial officer, like a justice of the peace. Um, so the founders never would have imagined that any city could station police officers at 172 places to copy down records of everyone who went by. That would have just been unimaginable. And even throughout most of history, I think people would have objected to living in a police state like that with this overbearing police presence. But this new technology makes it not just feasible, but really easy, frankly, for police to accomplish this thing that they couldn't have accomplished without the technology and to track innocent people for weeks at a time in a way that historically they've never been able to do.
Now, in the Illinois case that I wrote about, they talked about the separation. You have the cameras, and then you have the database, the learned database with all the data in it. And to me, that's where the real Fourth Amendment issue comes in because, we talk about privacy, and the courts talk about, the Fourth Amendment, your right to privacy. The Fourth Amendment doesn't mention privacy. It says you have a right to be secure from an unreasonable search. And that to me is where the biggest problem is you talked about tracking. It's this searching for the data, whether I'm tracking an individual or doing so, that's done without a warrant, without the necessary probable cause and judicial overview to make sure that the process isn't abused. How did that work into your case?
So, just a few things. I think the collection of data itself is the search, and it's not just whether, they pull up your information in the database. The fact that your information exists in a government database, and anytime the government wants, it can pull up this really intrusive record of your movements is a Fourth Amendment search. Now, like you, we take issue with the way the with current Fourth Amendment doctrine, which talks about subjective and socially reasonable expectation of privacy. We just think it's amorphous and indefinite, and it's actually led to an underprotection of Fourth Amendment rights against the government over time. So, like you said, we would go back to the text of the Fourth Amendment. The Fourth Amendment guarantees a right to be secure in certain things, in one's person, one's house, one's papers, one's effects. The right to be secure, we think, is much broader than just a right to privacy. The right to be secure doesn't just mean the right to be spared from something. It guarantees a right to feel secure as a citizen of a free country. And this type of dragnet surveillance infringes that right to be secure, kind of for similar reasons that we've been talking about. Um, because the government historically hasn't been able to track people in this way. And this sort of tracking has the capacity to chill people's movements, frankly, to chill their associations, to make them sort of look over their shoulder and wonder where the government is tracking them. So that violates this right to be secure. And then just going back to the idea of a search, we would say a search is something much simpler than the current legal standard, than what the current legal standard says it is. Search wasn't a term of art at the founding. It just had kind of an ordinary everyday meaning. It was just purposeful investigative conduct. And is this purposeful investigative conduct? Yes. I mean the contracts that Norfolk has entered into and that virtually every other jurisdiction has entered into say that the purpose of these systems is for investigating crimes and apprehending people who have committed crimes. And yet they just track every single person, whether they're expected of a crime or not. Um, So that kind of satisfies, we think, the requirement that there be a search. And when you actually go back and look at founding era documents, there are search warrants for people. They understood that you could search for a person, and that is what these systems are intended to do. They're intended to search for people. And so then just to get to your last point, we also ask the question of, is the search reasonable? And from our perspective, the key question there is it reasonable to allow police to have this much discretion without any judicial oversight? And, in the founding era, police didn't have much discretion to do things without judicial oversight. So we certainly think that this kind of upsets that balance. And just thinking of the specific abuses that the Fourth Amendment was intended to outlaw, it was intended to outlaw things like general warrants, where officers just had general authority to search whatever they wanted, to look for whatever they wanted, anywhere they wanted, right? And these systems are really kind of modern day. They create that same sort of modern day search authority. Any officer can go into the system. All they have to do is enter a reason for the search, but they're not required to have a warrant. They're not required to have probable cause. They're not even required to have reasonable suspicion, which is what they need for a stop and frisk on the street, right? They don't have to have anything. Norfolk's policy, for instance, just says it has to be for a quote unquote law enforcement purpose, but it doesn't say what a law enforcement purpose is. So that really just leaves it up to the interpretation of each individual officer and gives them unbridled discretion. And we've seen, some of the reasons that officers have entered for these searches. I can't really give you specifics around these, but some of them are just incredibly vague. You could never connect them to a specific investigation or, a specific rationale for the search. They're just these really broad reasons that, if you put in a search warrant, the search warrant would be denied. So we think these types of systems are not only are they searches, not only do they violate a right to be secure in one's person, but they're unreasonable because they just give every individual police officer unbridled discretion to track ordinary citizens across weeks and weeks of their lives.
I absolutely agree. And I've only got a few minutes left, but just to play devil's advocate, what do you say to the argument of, well, we need this data so that we can track the person who we find committed a crime? The one I always hear is, a child abduction, and we wanted to see where that car has been, get an idea of where the owner may live, or just even track it in real time as it passes by these cameras. What do you say to that type of argument?
I think in most of those cases, there are alternative investigative techniques that are more protective of people's rights than dragnet surveillance. And, oftentimes when things like that happen too, police can kind of pretty quickly know what sources of information they need to access. So it really doesn't require the same long-term tracking. And then, the final point is that all of our rights entail trade-offs. Our the First Amendment, free speech entails trade-offs. There are negative, I guess, in kind of economic jargon, externalities of having all of these rights, but it's better to have the rights than not to have them.
As Benjamin Franklin said, he who would give up essential liberty for a promise of temporary safety deserves neither liberty nor safety. So I agree. So,
Exactly.
Michael, before I run out of time, can you tell us a little bit about where people could find more, and maybe if they want to follow this case or just learn more about what you're doing, where should they go?
Yeah, if you search Institute for Justice Norfolk Camera Surveillance, you'll find our case page. It's also, if you go to ij.org and poke around, you'll be able to find it. We post important case documents there as well as news releases.
Like I said, it's a great site. I poke around it every so often, looking for cases that pique my interest. Michael, thank you for your time. Thank you for spending some time with us here today. I hope my audience learned a little something, and hopefully we'll have you back with some other great cases with great information, great news coming out of the Institute for Justice. And by the way, if you're looking for an organization support, IJ is one of the ones that I would recommend. So again, thank you and have a great day.
Thank you.